Thank you for listening to Shulchanaruchharav.com.
Must a guilty defendant in a court case in a Bezdin pay for the court expenses and litigation fees that were concurred upon the plaintiff, the winning party? So often in a court case in a Din Torah, there is a winning side and a losing side, and the question always comes up, in addition to whatever claim that was decided in court, who has to pay for the litigation fees and the court fees? Is it split even between the two parties? Do we find the guilty party or the losing party responsible for paying as well the share of his counterparty's litigation expenses or not? In addition, if a court case already occurred and a verdict was given, and the defendant, the losing party, refused to pay the plaintiff, something that unfortunately is not an uncommon occurrence, and the plaintiff then had to take matters into his own hands and go to secular court to enforce payment, may all of those expenses be placed upon the debt of the defendant, and he be required to pay as well for all the money that you spent on getting him to pay you. So the Gemara in Sanhedrin 31b records a discussion with regards to if you have two litigants involved in the case that live in different cities, and of course each one would rather the case take place in his hometown so he doesn't have to travel. Where should it take place? So as we know, the nitva, the one who the claim is being brought against, meaning the defendant, is allowed to demand that the court take place in the city that he lives in, and thus even if the teveya, the plaintiff, was forced to travel to a different area for the sake of the din Torah of the court case, the Gemara says that he does not have to pay him back even if he loses, meaning even if the defendant loses and the plaintiff in truth wins the case, the defendant doesn't have to pay expenses to the plaintiff. And so is recorded in the Rishonim, Tosfos Sanhedrin 31b, the Russian Sanhedrin 340, the Mordechai, and recorded in the Torah in the Shulchanaruch, chapter 14, in Choshen Mishpat, Halacha 5, that the losing party of a Din Torah does not have to pay the expenses of the winning party. However, and it's a big however, continues and writes the Rosh and the Mechaber in that halacha. If the losing party agreed to come to the Bezdin, and it was just that he lost in court, that's when he does not have to pay the plaintiff for the expenses. But if the losing party was playing games, even initially, and refused to come to Bezdin, and the plaintiff had to spend money in forcing him to appear to a Bezdin to arbitration, then the losing party is not only responsible for paying for what he lost in the case, meaning the verdict, but as well he has to pay for the expenses involved in getting him to show up. So to summarize, in the Din Torah, the losing party does not have to pay the expenses, the court fees of the winning party, and all expenses that are involved in the court case, such as the Bezdin itself. The Dayanim would be split between the two parties, and the lawyer fees or Tayanim fees would be covered by each party alone, if the losing party willingly showed up to court, even if he caused extra expenses upon the winning party through making them come to a further Bezdin and travel there. If, however, the losing party refused to come to court, and the winning party had to pay money out of his pocket to enforce him to show up, then the Bezdin would place the expense and reimbursement of that upon the losing party as well. Now this halacha may sound very unfair. So you're saying anyone can get up, if he has a vendetta, a personal vendetta against somebody else, drive him crazy in a court case, make up a claim that this person owes me $1,000, cause him tremendous agmas nefesh and suffering, and not be held accountable to pay any money for the winning side and reimburse his expenses in traveling, in getting himself a lawyer to defend himself. It sounds very unfair. So the Yeshuas Yisrael in Siman Yudalid, Halacha 5 writes, and so also concludes Rav Zalman Nechemya Goldberg, famous Dayan from Yerushalayim, that the above ruling in the Shulchan Aruch that we do not hold the losing party responsible to pay expenses only applies if they came with a truthful claim. And it just happened to be in court. It didn't find merit. Not all claims that we have according to Halacha are valid. However, if his claim was fictitious and dubious to begin with, and it was discovered to be that way in the Bezdin, then the Bezdin can place on him an obligation to pay for the court expenses of the winning party, even if he showed up willingly and he wasn't forced to come to court. And thus, a person cannot just decide based on a personal vendetta to make up a story and take someone to court and think he's going to come out monetarily unharmed, as the Bezdin will place upon him the liability to pay for all the expenses of the other party that he caused to come to court under false pretenses and claims. Now that that has been said, let's now go to the next case. The court case took place, a verdict was given, X has to pay Y a certain amount of money, and X refuses to pay, the losing party refuses to pay what the Bezdin adjudicated. What do you do in such a case? Usually the way it works is you get permission from the Bezdin and you take him to secular court. You take him to a civil court who will then force him to pay with all the legal maneuvers that they have, placing a close on his account, placing a lien on his home, etc., etc. But doing such a thing, going to the civil courts, you now have to hire a lawyer, you have to pay now for court fees. It's not so simple for the winning party. It's not a free ride. So whether or not the losing party who is now being taken to civil court to pay his fair share is liable to as well pay for the court expenses and litigation expenses of the plaintiff, so this Hashem will be discussed in a future halacha.